Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And somebody asked me a question, and it's something that we have seen before where, let's say one debt buyer sues you. Okay, so we'll call it Midland funding. So they sue you, you go to trial, you win your case. Hey, congratulations, that's fantastic. And then that debt buyer, again, we'll call it Midland, they transfer your debt to LVNV funding, to portfolio recovery, or some other debt buyer. And then that second debt buyer comes after you. Maybe they sue you, maybe they're credit reporting, maybe they're calling you, they're writing you collection letters. What do? So let me tell you, at least the way it works in Alabama. I suspect most states are this way, but certainly Alabama is. So when you beat that first debt buyer, then that is a decision from a judge that you do not owe that debt buyer any money. So what does that mean for debt buyer number one? Well, it means they better not be credit reporting. We need to look and see, did they violate the Fair Debt Collection Practices Act, the FDCPA, when they sued you and when they credit reported. And then again, talking about credit reporting, we look at the Fair Credit Reporting Act. Do we need to do a dispute with the credit bureaus and then see if that first debt buyer keeps it on your report? If they do, you sue them under that. And then the final thing would be under state law, particularly malicious prosecution, which is basically the idea, hey, you sued me, you had no probable cause to sue me, you sued me with malice. Well, how do we prove all that? Because they rarely raise their hand and say, I admit we had no probable cause, we had malice. You know. So we look at it and say, we had no evidence. You had no basis to sue me. Okay. And so that's on debt buyer number one. And then the final thing would be if they then transfer or sell that to another debt buyer, well, then that's a violation of law because they know when they transfer it to a second debt buyer, that second debt buyer is going to come after you. Now, what about debt buyer number two? Well, we look at the FDCPA. That says they cannot collect any debt that is not owed. There's other things the FDCPA says, but that's certainly one thing. If you don't owe the debt, they can't collect it. Well, if debt buyer number one lost the case and you don't owe them, well, then debt buyer number two certainly has no right to collect that. So we would sue debt buyer number two under the FDCPA. Whether they're calling, they're writing, they're credit reporting, they're suing. Now, if they sue, we certainly would defend it by saying, hey, look back at lawsuit number one. We beat debt buyer number one, so this second debt buyer can't be suing me. Okay, and that's basically an absolute defense. Okay, because the judge has already decided this. And then again, we look at malicious prosecution, FDCPA as their credit reporting. So the point is, when you beat a debt buyer in trial, so you get a ruling on the merits, what's called an adjudication on the merits. And that is where the judge says you do not owe them this money. And so I'm not talking about if you beat them on, say, statute of limitations. That's good, and that gives you a whole lot of options suing the debt collector, but that's something different. I'm talking about just they failed to prove their case. Well, then you need to look at the FDCPA, the FCRA, state law claim, and then if somebody else calls you, or writes you a letter, they show up on your credit report after you've already beat that first lawsuit, then what I take that as is that second debt buyer is saying to me, please, I'm begging you, please sue me. So, hey, we don't want to reject them on that. So we'll accommodate them and we'll sue them for that. So I hope that this is helpful and appreciate you watching this video. Feel free to like it, or if you know somebody that might benefit from this, feel free to share it. And I will catch you guys later. Okay, bye-bye.